Good afternoon, distinguished guests, friends, students, and faculties. My name is Sarah Wu, the Mistress of Ceremony. Today, we commemorate the 235th anniversary of the United States Constitution. In doing so, it is an honor to welcome Professor David Forte from Cleveland State University School of Law, as well as Professor Jessie Hill, Judge Ben C. Green, Professor of Law from Case Western Reserve University. Our guest speakers are here today to discuss post-Dobbs, the state and federal landscape. The Society for Constitutional Policy appreciates your time to share your thoughts on questions provided by our panelists, as well as our audience. Please allow me to introduce our student panelists. I'll start with the lady that's immediately next to me. We have Ms. Hannah Bolander, Mr. Rohi Rakit, and last but not least, Ms. Kelly Mallon. Now, please join me in welcoming our moderator, Mr. Alejandro Pascal. Mr. Pascal, the floor is yours.
Thank you, Ms. Wu. Ladies and gentlemen. Ladies and gentlemen, as Ms. Wu stated, we are celebrating the 235th anniversary of the U.S. Constitution. The founders amended the Constitution with a Bill of Rights, where the 10th Amendment reserves for the states and the people the powers not delegated to the federal government. Truly, this amendment plays a special role in American jurisprudence, especially today. This summer, Dobbs v. Jackson Women's Health Organization overruled Roe v. Wade and placed the right to abortion in the hands of the state. With the help of Professor Forte and Professor Hill, we will examine the state and federal landscape post-Dobbs. The historical context begins in 1973 with Roe, which guaranteed women a right to obtain an abortion until the point of fetal viability. In 1992, Planned Parenthood v. Casey, the court reinforced Roe, holding the states could not impose an undue burden on the right to obtain an abortion. Recently, Mississippi, asserting a state's interest in protecting unborn life, passed the Gestational Age Act, which banned abortion after 15 weeks. Jackson Women's Health Organization filed a lawsuit challenging the Gestational Age Act. The lower courts decided in Jackson's favor, and the Supreme Court granted cert. In June, the court overturned both Roe and Casey in a 6-3 decision in favor of the Mississippi statute. The court in Dobbs asserted that the substantive due process clause of the 14th Amendment does not confer a right to abortion. The court stated that abortion rights are not deeply rooted in American history and tradition. Today, states regulate abortion. Some states, such as Ohio, have shortened the period when women can get an abortion by passing heartbeat bills. Other states have banned abortions completely. On a federal level, Senator Graham proposed to ban abortions after 15 weeks. Thus, in the wake of Dobbs, the legal and civic landscape are anything but settled. Both pro and anti-abortion protesters have rallied outside the Supreme Court. Planned Parenthood, Women's March, and others have launched over 450 large-scale marches and protests. Citizens in conservative Kansas voted overwhelmingly to keep the right of abortion in the state's constitution. While some politicians have celebrated the end of abortion at the federal level, others have excoriated the court for dismantling precedents settled for over half a century. And so we come to today for an important consideration of the state and federal landscape after the decision in Dobbs, and are honored to welcome Professor Forte and Professor Hill. Professor Forte and Professor Hill will each have 12 minutes for opening statements. Professor Forte, the floor is yours.
Thank you. Thank you very much. I was reminded as we began today of that old Paul Simon song, 50 Ways to Leave Your Lover. Well, there are many, I don't know if there are 50, but there are many ways to overrule a case in the Supreme Court's history. Sometimes the court just pretends it's not there, such as the case of Buck versus Bell, in which the Supreme Court in 1928 upheld Virginia's statute of compulsory sterilization of those who were retarded. And Justice Oliver Wendell Holmes's famous statement, 3 generations of imbeciles are enough. Sometimes the court will simply wave at it and say it no longer counts. That actually happened this last term in a case of Kennedy, that Kennedy was the praying coach at the 50-yard line. And the Supreme Court said, oh, by the way, the strict separation rule that we articulated 20, 30 years ago in Lemon v. Kurtzman, no longer, we've abandoned that. Sometimes the court knows that the 800-pound, how many pounds does that gorilla weigh? I always was it 400 pounds or 800 pounds? Does anybody know?
800.
Thank you. Okay, I'll note that. The 800-pound gorilla in the room in Brown versus Board of Education, which was Plessy. Plessy wasn't mentioned, and yet it was overruled. And Brown versus Board of Education, by not encountering the principles that the majority in Plessy claimed allowed for separate but equal, came up with a half-baked sociological basis for the end of segregation, which has caused untold problems ever since, as we've tried to find out exactly how we articulate the legal harms segregation inflicted on black children so that we can fashion an appropriate legal remedy. Sometimes the court does what it does in Dobbs. It handles the case top to bottom. It blinks not once. It goes all the way through the history. It goes all the way through the faults. It stands up straight and proud, and it says, this is why we're overruling it. Take your shots if you want, but we're not going to hide. And we're going to tell you exactly why we're overruling it in a way that Roe v. Wade never really told you why it invented a right to abortion in the first place. So that puts me in memory of the Greeks. Now, I want to go back behind Plato and Socrates. I mean, let's get back to the real Greeks. Zeus. So Zeus and Hera were the brother and sister of King Cronus, the Titan king. Excuse me, and as they grew up, Hera got this kind of thing for Zeus, and she seduced him. She's had this postmodern version of marriage, and she seduced him, and they got married, and but Zeus wasn't the stay-at-home type. He just slept around with all the goddesses and humans that he could find. He really invented the hookup culture back then. And the last mortal that Zeus slept with and impregnated was a woman named Alcmene. And she was to bear Heracles. So Zeus goes home to Hera and says, you know, yeah, I'm bearing a lot of children outside the marriage, but I'm going to name one after you. Somehow that didn't console Hera very much. Heracles means the glory of Hera. And so this was going to be Heracles, but she, in response, made Zeus promise, listen, there's another woman who's pregnant, and if she bears a son first, Eurystheus, then you will make him king and not Heracles. And Zeus agreed. The problem was Heracles' mother was further along in the pregnancy than Eurystheus' mother. So what Hera did was she sent some witches to be able to induce early labor so that Eurystheus would be born in the 7th month, or as that great poet Harry Blackman would put it, he was born after viability so that he could have a meaningful life of his own. In other words, being a king, which is not bad to be a meaningful life. Now, she had to stop Heracles from being born, so she went to terminate that pregnancy, as Justice Blackman would say, in the final trimester. Nonetheless, she didn't succeed, and Heracles was born, but he was born too late. Eurystheus got the crown, so all Heracles could do is become a god and a hero and have lots of adventures, which were written down in the Greeks. So there we are. Now I get to the point. Hera was never consoled to the fact that Heracles was born, so she put a spell on him after he had grown up and married and forced him in a state of insanity to kill his children and his wife. When he came back to his sanity, he betook himself to the oracle at Delphi, and she said, for your penance, you're going to have to do 12 labors. He gets through 4 of them, and the 5th one was this. There was a king named Augeas who had immortal cattle, immortal cows, immortal goats, and every night they would go into his stables. And for 30 years, they sort of built up what cows and goats and things do when they go into stables. And so Heracles was said, you've got to clean out the Augean stables in one day. Now, being an engineer, he diverted a river, cut a hole in the front of the stable, in the back of the stable, and let that river just flush out the stuff in a day. That's what Alito did in this case. He got rid of 40 decades of bad precedent, ungrounded precedent in the Constitution, and he let you know how. He went through the history, much of which was fictional by a law professor named Means, and then repeated over and over again. He went through the statistics, many of which were fabricated, intentionally fabricated in order so that black men could have the basis for finding this new right of abortion. He listed the abortion statutes that were present at the time that Roe v. Wade was enunciated, 30 of them in some way or another limited abortion. He went through the whole common law of quickening, and he said what had to be said. He said, this case, let me get that quote, he said, this case has no grounding in history. It is egregiously wrong and has created great distress in the body politic ever since. He then went on to determine how we should find whether there is a substantive due process right. That is, a right that's not in the Constitution, but that the court wants to find and put into the Constitution, even without amendments. Even without amendments. And there were 2 ways the court used to try to find a standard by when they looked around to see if there should be some right that's not in the Constitution that we should put in the Constitution through the Due Process Clause. One was in accord with the traditions of our people. So, for example, the right to jury trial. They struck down Louisiana's jury system, which was based on the civil law system of Europe and didn't have a jury trial on the basis it was not in accord with the traditions of the American people, which had the common law 12-person jury. The other was whether it was necessary to a scheme of ordered liberty, whether you could think of any political entity of any quality, of any representational constitutional quality, that could live or exist without this right. And so, although Alito said, because of the supreme moral question of abortion is so unique, we are not going to attack other substantive due process rights, such as the right of contraception, the right of same-sex marriage, that have been articulated. But we're going to set a double standard if you want to get any new ones. If you want to think, he's telling future courts, of a right that's not in the Constitution, you have to justify it by both standards now. You have to find that it's within the traditions of our people, and you have to find that it's in a civil society cannot be conceived without this right being in existence. And so what this case stands for is that it returns the democratic process to the American people. What was pumping along in the 1960s and 70s, abortion laws were being gradually liberalized. And what the Supreme Court did was make this a national issue that has distorted the Supreme Court's appointment system, has distorted political debate, has made this the primary issue of both political parties rather than other issues that are of such moment. Now, that's the first thing he did, is he restored the basis of when the people can find something that's fundamentally valuable, that's not articulated in the Constitution. We argue it out and we decide it. That he's given back to us. The second thing is he's reestablished the rule of law. Roe v. Wade had so many internal contradictions. It was that even when it was reaffirmed, not reinforced, reaffirmed in Casey, the plurality, which was the ruling opinion ultimately in Casey, said that although we wouldn't decide Roe the same way, of course not. Nobody defended the reasoning of Blackmun because it was indefensible. His history was indefensible. All those years, they simply relied on stare decisis. We got it, so we're not going to leave it. That's not the rule of law. The rule of law is based on reason. It's based on consent of the governed. It's based on constitutional determinacy. That's what the rule of law is based on. And that's what Alito has returned to the body politic with this decision. Yeah, he cleaned out the stables, and the stables needed to be cleaned out. And we have our Constitution and our democracy back. Thanks.
Thank you, Professor Forte. Professor Hill, you have 12 minutes now.
All right, thank you very much. What I want to spend my 12 minutes doing is to just make some general points about Dobbs. And then I do want to say a bit about how I see it as having affected so far the state and federal landscapes with respect to abortion and abortion rights. I will just briefly touch on what Justice Alito said in the Dobbs decision. I think my colleague, Professor Forte, also did a very nice job summarizing the gist of the opinion, so I don't have much to add. But I'll just sort of re-summarize a couple of points. So this was a very textualist, to lay the groundwork for what I'm going to say next, which is this was a very textualist and originalist decision. Justice Alito said there is no specific textual language in the Constitution referencing privacy or abortion. So that was sort of the initial basis for finding no right to abortion in the Constitution. And then said, but even if there is no text protecting a particular fundamental right, or a particular right, we can determine that the Constitution still protects that right if we find that it has always been protected throughout our history and tradition. And then he reviewed the Anglo-American legal tradition, focusing on the 19th century when the 14th Amendment was adopted, but going back even further than that, and found that the right to terminate a pregnancy had not been a protected right throughout our history, and in fact had been criminalized. And then Justice Alito went on to apply these various factors that the Supreme Court applies when it's trying to decide whether or not it's acceptable to overrule a case. In other words, whether it's okay to abandon the rule of stare decisis, which holds that generally the court will not revisit its precedents. Even if they are wrong, it won't revisit them unless they are, extra special wrong, or unless there is a really compelling reason to go back and revisit them. Justice Alito considered all of the factors and decided in this case that they all weighed in favor of overruling the precedents Roe v. Wade and Planned Parenthood v. Casey, which was a 1992 case that reaffirmed, although with modifications, the essential right to end a pregnancy. So the fact that the Supreme Court decided in Dobbs, of course, means that it is no longer a fundamental right protected by the U.S. Constitution to terminate a pregnancy. Instead, as Professor Forte said, it is left up to in the court's words, the Democratic majorities to decide what each state's abortion policy should be. So we're clear on that, right? Dobbs didn't obviously make it illegal nationwide, didn't make abortion illegal nationwide. It left it up to each state to decide. So maybe it will come as no surprise, I have a few criticisms I'd like to share of this approach. And then, like I said, say a little bit about what the impact has been in my view. I'm not going to dispute that there's no text in the Constitution that says abortion or privacy, although the Constitution does say liberty and uses lots of other big general terms like that. It's not an administrative code. It's not meant to prescribe rules for every situation that might be encountered. It's a very general and brief document that speaks in broad terms. It also has a bit of language called the Ninth Amendment that suggests that there are unenumerated rights as well, rights that are not enumerated in the Constitution. It says, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Also, I'm not going to dispute Alito's history, Justice Alito's history, although it could be disputed, and actual historians, of which Justice Alito is not one, have disputed this history and did file some historians filed an amicus brief in the case, coming to the exact opposite conclusion about the history of abortion, finding, in fact, it had been a widely accepted and widely practiced throughout the 19th century. And I'll just add as a point to that in fact, throughout much, and before the 19th century as well, and throughout much of our history, there was not a very clear distinction drawn between contraception and abortion. So if you're wondering, and I know that's not exactly the topic today that we're talking about, but if you're wondering where the future of contraception is going, there's another thought. That really, throughout our history, we really didn't distinguish much between contraception and abortion. But I will say that even if we accept Justice Alito's version of the history, any appeal to what has been a broadly accepted right in the 19th century and earlier is, of course, an appeal to a time when women couldn't vote. So women could not have helped form that legal history that we're talking about. It was a time when marital rape was legal. It was a time when women had virtually no rights or legal personality separate from their husbands. We can say it's a time when unquestionably, as at many points in our history, the law really functioned to protect those who already had power. In particular, one interesting thing about the criminalization of abortion, as Justice Alito notes, that the criminalization movement really started around the mid to late 19th century. And he points out that this was also the time when the 14th Amendment was adopted. 1868 was when the 14th Amendment was adopted. And that was also the same time when abortion started to become criminal throughout the United States. Before that, it really wasn't explicitly criminalized. It was also a time when, in that movement, that criminalization movement was actually led by doctors in the US. And it was a time when doctors were starting to professionalize, and they wanted to start to institute rules and education requirements to raise their status in society. And part of that professionalization process was that they wanted to sort of claim reproduction, childbirth, pregnancy as medical matters that should be within the domain of medicine and only dealt with by trained physicians. Before that, it had been very common for midwives, who were sometimes referred to as irregulars. They didn't have formal education in medicine necessarily, to help women both through childbirth and also with abortions. And so because they were concerned about keeping these irregulars out of the practice of medicine and raising their own status, and also as part of, as also their other concern was that they were afraid with the budding first wave of the women's movement at that time, that women, if they could control their reproductive lives, might abandon their maternal destinies and their roles in society. And they were particularly concerned that white women might do this. They started this moral campaign against abortions and to establish themselves as sort of the gatekeepers of pregnancy and childbirth. So it's kind of a historical contingency, actually, that this was all going on at the same time as the 14th Amendment, which is the source of formerly the source of the right to abortion, was adopted. So, okay, all of this, finding no right, the court says, well, then we'll leave it to the democratically elected majorities in the states to decide what abortion policy should be. Now you can say, well, good, you've pointed out this history, this sexist history in the US, the fact that women couldn't vote. Well, women can vote now, right? And if women want to get rid of abortion restrictions, they can go ahead and do that. I think it's deeply problematic to take that perspective, not only because, of course, it ignores how structural inequalities that were in place for centuries can continue to have an impact today, but it also ignores our highly unrepresented, highly gerrymandered legislatures that are making these rules today. I want to say more about that last point in a moment, but I just want to take a moment to make the affirmative case that the Constitution, with its concise and broad terms, is in fact meant to be a delegation to future generations to determine what the meaning of liberty and equality are. And that a constitution that cannot evolve to deal with modern problems and embrace modern understandings is not worth the paper it's written on. This is not to say that history and text are irrelevant, but just that they should be broadly understood. And so, although perhaps the application of liberty to abortion rights is relatively new in our history, the right to bodily autonomy and to family privacy is not a new right. This right goes back at least to the beginnings of the 20th century and arguably much earlier. Okay, so a couple of points about impact. I think great distress in the body politic would be a good way to put it, actually. Many states, right after Dobbs, tried to resurrect abortion laws that had been passed before Dobbs came down, either 19th century abortion laws, okay? Remember, we're talking about democratically elected majorities in the 1800s who passed these abortion laws that prosecutors then began enforcing in the states, as well as laws that were passed while Roe v. Wade was the law of the land, in which the legislatures knew would never go into effect, or thought would never go into effect, were then springing into effect post-Dobbs. I can say that they were certainly written not written by people with the expectation that they would ever be put into practice. They were not written with consultation from medical professionals, and we are seeing right now deep distress as doctors are struggling to understand the meanings of the limited medical exceptions and how they impact patients as they are being forced to send 10-year-old rape victims across state lines to seek abortion care, and as they are being forced to choose between facing felony criminal penalties and living up to their professional ethics principles, as well as avoiding malpractice liability. So I think that the upshot of Dobbs, the medicine, if it is medicine, has been much worse than the disease that it was meant to cure. And I think I am out of time, so I will stop there. Thank you.
Thank you, Professor Hill. We will now proceed with questions from the panelists. Professor Forte and Professor Hill, you have 5 minutes to address the questions, then 3 minutes to respond to the other speaker's point, and finally 2 minutes to defend your original point. I would like to invite Ms. Wolander to ask her first question.
Professor Forte, please summarize the impact that Dobbs will have in Ohio.
Anybody have a crystal ball? Well, so things are happening in both directions in Ohio. The background, and I have how many minutes for this? 5?
5 minutes.
I don't think I'll need that much, so I'll put some in the bank. All right. But let me, you see, after, I'll give you the background of what was happening in Ohio. After Casey, which upheld the right to abortion, the right to life movement was very demoralized, the majority of which, by the way, are women. At first there was some actual violence against abortionists, abortion clinics, and the right to life movement recoiled from that. And by the way, there's now violence against pregnancy centers and churches. There's over 200 instances since Dobbs across the country. And I'm sure the pro-life people, pro-choice people are going to recoil from that. And I mean that sincerely, not sarcastically. But beginning around 1995, the pro-life movement decided to attempt to protect unborn life as best as possible in an incremental way. And every piece of legislation, though, did have a point. It had a moral point, and the point was, this is a living human being. This is a living human being. And so you had partial birth abortion laws, eventually ultrasound laws so that women could actually see the fetus. You had laws of fetal homicide, so that if someone strikes a woman and the child dies, the child is an independent victim, and the person is accused of attempted homicide or homicide on the child. You had waiting periods. You had informed consent laws. You had 20-week bans, fetal pain bans. And all these were designed to point to the humanity of the unborn. The heartbeat bill was based on this. We found out in the early, around 2010 to 2011, that some longitudinal studies had been, I didn't see the time, what did you say, 3? The longitudinal studies on pregnancy had determined, which were not available to the Casey court, had determined that, and there were a number of them, and they all pretty much varied somewheres depending on the locale in the world and so on, pretty consistent, that the probability of a child reaching term after there is cardiac activity detected in the fetus was 95%. In other words, as one obstetrician told me, said, it takes 1,000,001 things for a spermatozoa to reach an ovum and 1,000,001 things for that fertilized ovum to be implanted. But once that happens, once cardiac activity happens, it's pretty clear sailing. What most doctors do is monitor the pregnancy to make sure it's going well. But nature will take its course, and 95% of those children will reach term unless there's an intervention of lethal force. And that's what the pro-lifers are trying to say. And they won on that. I think they won on the battle, on the moral battle, because now the argument is not whether the fetus is a human being. The argument is it doesn't matter. It doesn't matter. It's my body. It doesn't matter what happens. That's the argument. I have a privacy right. You can't look into it. It doesn't matter. You know, and Abraham Lincoln was having the debates with Stephen Douglas. At one point he said, Judge Douglas, he said, is not the Negro a man? And Douglas says, I'm talking about self-determination. Let each territory decide whether they want to have slavery. And if they decide to have slavery, let each person decide whether he wants to own slavery. I'm in favor of self-determination. And all Abraham Lincoln said, but is not that a person?
Thank you, Professor Forte. Professor Hill, you have 3 minutes.
Well, thank you. I guess I want to say a few things about the impact in Ohio from a different perspective. Certainly, there is actually, you may or may not be aware that in Ohio, the day the Dobbs decision came down, a ban on abortion starting at the fetal heartbeat, which is as early as 6 weeks of pregnancy, went into effect. I actually am not certain that the 95% figure is accurate, but I want to set that aside and say that in 6 weeks of pregnancy is measured from a person's last menstrual period. That means by the time you conceive, you are actually already 2 weeks pregnant. So a ban on abortion at 6 weeks is really a ban on abortion at 4 weeks after conception, so quite early, far too early for most people to access abortion in Ohio. As a matter of fact, there have been studies that say, although many people discover pregnancy by that stage, it's nearly impossible for about 89% of Ohioans to access abortion before that point of pregnancy, because you have to, first of all, visit the clinic twice, make 2 separate trips in Ohio, at least 24 hours apart to access abortion. And of course, there are childcare issues. 60% of people who have abortions already have 1 child. And there are other logistical and financial, of course, concerns with accessing healthcare that is not generally covered by insurance or Medicaid in Ohio. I want to say that the impacts are extreme, and that law is currently temporarily blocked, but should it go back into effect, it is likely that every clinic in the state will stop performing abortions, every freestanding clinic. You will be left with hospitals that perform them only in extremely limited circumstances, and will be unable to train residents competently to provide those abortions, even in emergent circumstances. So if abortion is illegal, residents can't get the training enough experience doing it to learn how to perform it. And so then they are not going to have the experience that they need to be able to do it when patients show up in emergent circumstances. Of course, I want to say that this law is wildly, wildly unpopular now that folks have been living under it. A recent study or a recent survey indicated 68% of Ohioans reject this law, oppose this law, and perhaps they will at one point get to vote on it at the ballot.
Thank you, Professor Hill. Professor Forte, you have 2 minutes to defend your point.
So the other action that's happening, I'm going to just continue on, Jess, because we got a lot more to do. The other action that's happening that we ought to watch is a judge just found under a kind of substantive due process argument under the Ohio Constitution that there's a right to an abortion. And I think that's where the new kind of judicial activism action is going to be. Pro-abortion rights people are going to attempt to find in their state constitutions that same right which never existed there, that Justice Blackmun found in the federal constitution, which never existed. I don't think, Jess, maybe you disagree on this, I'd like to hear. I don't think that decision's got much of a shelf life. I don't think it's going to be upheld on appeal, but we will see. The kind of thing that's happening in terms of public perception is this. The majority of people do not want abortions in late pregnancy. That's quite clear. The majority of people think there should be an abortion right in early pregnancy. That's the current issue. So my point of view is this. We should fight it out at the state level because ultimately the issue is going to be a moral one, as slavery was. It's going to be a moral one, and it's going to be up to the people of each state to decide whether to protect unborn life or not to protect unborn life. I'll give you one story to end this. It's the question of privacy here. I was once on the Lakewood Board of Building Standards, and the city attorney would sit beside us, and he'd look over the arrest records of what had happened the night before, as he'd be there to advise us if anything came up. And one night he's there, and I'll just take 30 seconds, thank you, if you don't mind. And one night he's there, and he starts chuckling, and he hands me over the arrest report. And it turns out some fellow had beat up his girlfriend, and fortunately she had called the police and charged him, and he was brought in, given the Miranda rights, and after giving the Miranda rights, he gives this statement against interest. He says, quote, "What kind of country is this when a man can't slap a bee around in the privacy of his own apartment?" The point is, privacy is not a bar to moral harm. It is not. If you own a company and you have workers, it's your property. If you own this plantation and you have slaves, it's your property. It's not a defense to moral harm. It's not a defense to hurting people.
Thank
and
you,
so
Professor
that's why
Forte.
this argument of privacy, I don't think, has much traction.
Thank you, Professor Forte.
I concede the next minute to you, if you want, of mine.
Mr. Rekit, if you could ask your first question.
Professor Hill, in your article titled "The Geography of Abortion Rights," you discuss at length the relationship between abortion and geography. And of course, in your opening statement, you also briefly discussed gerrymandering. Can you please explain to us how Dobbs will affect geographic inequality?
Oh, wow, that's a big one. Yes. So the impacts of Dobbs will not be felt equally, and that is understood widely and in many respects. So there are all kinds of inequalities. I mean, first, we know that just on the state level, some states will expand access or keep access to abortion. Others will greatly restrict it and have already. So partly, you may live in a state where a majority of people, or just slightly less than a majority of people, support abortion rights, where the overwhelming majority of people support abortion rights, say early in pregnancy, and yet have zero access to abortion in your own state. So then, what else flows from that? Well, there is that fact has a disproportionate impact, of course, on people who cannot travel for whatever set of reasons, who don't have the financial means to travel out of state, who have to work and don't get paid for time off if they take time off, who don't have reliable childcare. Probably they have to spend the night the further they have to travel out of state. They may have to spend a night out of state and they don't have overnight childcare. There is the other interesting thing about the impact of Dobbs is that it's not like, one state on, one state off, one state on, one state off. It is a broad swath of states in the Southeast and the Midwest that are in the process of banning or likely to ban abortion, which means that, some people, depending on where they're situated, will have to travel quite far to be able to access services. We also know that people who live in rural settings who already struggle to access health care are going to struggle further to access needed reproductive health care. And in speaking with folks, with physicians who deal with patients who need abortion care, I've heard stories about people who have said, that they simply cannot travel out of state. And then I've heard stories about patients who say, well, this patient is in a really bad situation. She's pregnant with triplets. If she continues to carry the triplets, all of them will die, but she can save one if we can terminate two of the fetuses, of the embryos. And I guess she's got the means, so I'll be able to send her out of state to go seek care. If you have great insurance, if you have financial resources, this is not going to have the same kind of impact on you. So obviously, it should be evident, but of course, the people who are most impacted by restrictions that have a disparate financial effect are also predominantly, or disproportionately, I should say, Black and brown people in the U.S. who are going to have a harder time accessing care. By the way, those are also the people who suffer the greatest burdens of infant and maternal mortality in the state, because there did not come along with the abortion ban in our state or in any state I'm aware of an expansion of social services, of access to prenatal care, of access to any sorts of food assistance, food stamps, anything that people might need to have healthy pregnancies and to have healthy children. So I think that's one of the really important aspects. I guess just briefly, you also did mention gerrymandering. This is a little bit of a separate point in my view, but our legislature is currently in the process of fighting the Ohio Supreme Court, which has now, I think, 5 or 6 times, I've lost count, declared that the maps that it's drawn are unconstitutional under the Ohio Constitution and must be revised not to be so slanted toward the party in power. And they have continually resisted that effort to redistrict, to give power, a greater proportion of power back to the people so that the people can choose their representatives rather than the other way around, so that the voters can choose their representatives rather than the other way around. And so, that this, and very much wrapped into this fight is the fight against, is also the issue of abortion restrictions and whether we're going to end up having even more abortion restrictions that do not reflect the will of Ohioans, or whether we are going to end up with a more democratic and responsive legislature.
Thank you, Professor Hill. Professor Forte, you have 3 minutes. 3 minutes.
Accepted. I take one of Professor Hill's points. I think the pro-life movement, of which I have been pleased to be part of for so long, needs to do more on the affirmation of child care, the dignity of women and the profession. I think we need to do a lot more on that. And that's what happened after the Civil War. The slavers said, what are you going to do with all these black people? They won't have anything to work. They'll starve. The best place for them is to keep them in slavery and bondage. Well, the federal government did try to do things with the Freedmen's Bureau and other things for black people. Yeah, I think I think we need to do that. But I do disagree on calling an act of killing another person care. Abortion care is no longer care to me as Holocaust care would be. Frank, I really wince at that situation. An obstetrician told me that when you think of it, abortion is an induced disease. Because a woman who is pregnant has all kinds of hormonal and other reactions designed for her health and the health of her baby. And what abortion does is intrude into something that was not expected in terms of nature or the history of the clinical history of that woman. So she called it an induced disease. It's not care.
Thank you, Professor Forte. Professor Hill, you have 2 minutes to defend your original point.
So I guess I just wanted to respond to that last point. I think that this is definitely part and parcel of the anti-abortion perspective, is to see pregnancy as natural, as good, as a woman's fate that she should accept, and any medical intervention that would stop it as harmful and, you know, not healthcare. I mean, I think there are many medical professionals who would disagree. Of course, you can find some on the other side as well, as you've pointed out. But I think that, you know, lots of things happen naturally. I mean, cancer occurs naturally. You know, bones and joints disintegrate naturally. I think, you know, that we engage in healthcare interventions so that people can regain functionality and health and set their life course according to what's appropriate and what, you know, what is best for them. And I think that that's in that context, of course, it's medical care.
Thank you, Professor Hill. Ms. Mallon, if you could please ask your first question.
Professor Forte, Justice Ruth Bader Ginsburg said that the right to abortion would be more firmly protected if it were grounded on equal protection. Do you agree?
That's a wonderful question, and I'm glad you did that. You said that. She also said early on that she regretted Roe v. Wade because she thought there was a growing consensus among the people in the legislative bodies to develop a gradual understanding of when abortion would be appropriate for free choice and when it wouldn't be. And she said to have that democratic process. She didn't use the word aborted, but be appropriate. To have that democratic process stopped, she regretted very much. And just to go on her point in that regard, and I'll get to the equal protection point in a moment, to go on that point in that regard, she was right. I mean, look at the harm to our political process. Abortion should not have been, it seems to me, a national issue politically. Biden administration wants to codify Roe v. Wade. Lindsey Graham wants to codify the Mississippi law nationally. The court made it a national issue. And so I think Ruth Bader Ginsburg had real good perception on that. I disagree with her view on equal protection because I don't think it's a situation of just because women get pregnant and men don't, that there's an equal protection situation. Pregnancy is a medical event, a physiological event that occurs. It occurs, happens to occur. No, it definitely occurs in women, real women, not ersatz women. It occurs in real women. And so as the court said, and Alito met this, he said, pregnancy is not a sex-based discrimination, and therefore it doesn't fit under equal protection. I don't think the equal protection argument was going to have much trenchantcy in the future. I think very few people took it up on the pro-choice side in the courts. She spun it out, but it was never really developed much beyond that.
Thank you, Professor Forte. Professor Hill, you have 3 minutes.
Thanks. So I have great respect for the late Justice Ginsburg, and she did have her criticisms of Roe v. Wade, but she was a strong supporter of the right to abortion. But, you know, I'm not sure from a legal sort of constitutional perspective, I'm not actually convinced that we would be in a much different place today if the court had embraced an equality rationale. So maybe we kind of land maybe by different routes, but end up in the same place on this point. I think, you know, although I think it's a questionable assumption that pregnancy discrimination is not sex discrimination, which is what the Supreme Court has said, and although I think it's fairly evident that abortion restrictions are grounded in sex stereotypes, assumptions about women's role in society, I do, you know, I don't think that the court would be saying something different today. I think it would have, after all, within a couple of years of Roe v. Wade, the Supreme Court actually held that laws that discriminate based on pregnancy are not sex discrimination. So I don't know that it would have carried the day from a constitutional perspective. You know, I still do find the bodily autonomy and the right to make, you know, deeply personal decisions to be a very compelling basis for the right to terminate a pregnancy. You know, I think we've talked a lot about democratically elected majorities making moral decisions. You know, I think if you ask people, do you want judges making this decision or do you want democratically elected majorities making this decision? I think they would say neither. I think they would say individuals should make this decision. You know, individuals are moral agents. Individuals are capable of working through the moral and spiritual implications. Individuals can come to their own determination about what the moral status of a fetus or an embryo is. There's certainly no widespread agreement in society on that point. Different religions say different things about this. And so I think that the core of the issue is that it's really not for any government official to decide. I think it's for the individual to decide.
Thank you, Professor Hill. Professor Forte, you have 2 minutes to defend your original point.
I accept Professor Hill's point of view. It's well stated, but wrong. The question of I'm getting my train back because you triggered something in my train of thought here. I want to move to whether abortion should be criminalized or protected at the national level. If there were a pro-life amendment that was being put forward in Congress, I of course would support it. It's like the 13th Amendment. There would be no slavery, no killing of unborn children. But in terms of the body politic, I think it's much more healthy for legislatures to decide. Professor Hill said the individuals should decide. Well, we decided to take that decision away from people who own slaves. We decided to take that decision away from husbands who rape their wives. We decided to take many decisions away from people who had power over others. You know, there have been 3 major substantive due process moments in our history. Each one instantiated the right of a victimizer over a victim. Dred Scott, under the Due Process Clause, said that the Congress could not take away the right of a man to own another person as property. Lochner versus New York said the Constitution could not allow a state to prevent someone who had a lot of power in business from dictating how his worker would live and what kind of wage he would have. Roe v. Wade said the Constitution cannot prevent a woman from putting to death her own child. Substantive due process victimizes each time it has been used.
Sorry, we've run
You're welcome.
Well, thank you for stopping this time. But for the interest of time, we'll go for the next question by Ms. Bolander.
Professor Hill, Justice Clarence Thomas argues that the court should reconsider Griswold, Lawrence, and Overthrow. These deal, respectively, with contraception, sodomy, and same-sex marriage. Could these holdings be challenged successfully?
Well, I kind of alluded to this, so thank you. I kind of alluded to this in my remarks. I do think that those rights are next potentially on the chopping block. So the logic of Justice Alito's opinion really does not leave any room for recognizing or continuing to recognize those rights should they be challenged in the future. I mean, again, the answer was quite simple in Justice Alito's view, and as Professor Forte presented it, right? Is it in the text of the Constitution? Contraception, same-sex marriage, same-sex intimacy? No. Did our history and tradition, protect those rights? As I alluded to with contraception, I mean, if it didn't protect abortion, it didn't protect contraception, certainly not. Same-sex intimacy and same-sex marriage, no, there's not a robust legal tradition of protecting those activities. There's in the Obergefell v. Hodges case, in which Justice Kennedy found and vindicated the right of people to marry someone of the same sex. He found that the history was not necessarily strongly to the contrary, but he did not find that there was a legal history of the kind Alito was looking for in this case that would support those rights either. So, and I don't think Justice Alito's attempt to distinguish those rights as saying, well, those don't involve, a potential life, and so there's a moral distinction. Again, I just don't see where that comes from. I mean, that's not a part of the originalist methodology. That is Justice Alito's own moral ipse dixit. That's his moral view. I thought we were just talking about justices not imposing their moral views on the rest of the country. I think that is a very key moment in the Dobbs decision where it's clear that that's exactly what Alito is doing. He then says that, well, each of these rights would be subject to their own stare decisis analysis, and he would go through these various factors about whether the quality of the reasoning of the decision was strong, whether it was, workable, whether it related to other rights, whether people had relied on it. Again, I'm not sure that any of those rights really definitively comes out differently under the stare decisis analysis. The Griswold decision that protected the right to contraception has been heavily, heavily criticized since it was decided. Maybe the standard is a bit more workable in the sense that it's strict scrutiny, but that would be probably the only element that would cut in the other direction. And I expect we'll see it. I mean, I expect that we will see, we've already seen attacks on contraception by religious employers and who don't wish to provide coverage in their insurance plans for certain forms of contraception that they object to, or any contraception that they object to. I expect we will see a state that chooses to try to ban certain forms of contraception that, again, although the science doesn't really support it, there are certain forms of contraception that some people think are equivalent to abortifacients, that they are equivalent to abortion because they have a post-fertilization effect. The problem is that really the science hasn't borne out the idea that they even have a post-fertilization effect. But I expect we may well see state legislatures trying to ban those forms of contraception, and then those cases working their way up, and then the Supreme Court will be forced to decide, first of all, are states at liberty to define these forms of contraception as abortion and then ban them, right? Or can they just ban contraception outright? So I expect that we will see that in coming years.
Thank you, Professor Hill. Professor Forte, you have 3 minutes.
This is what I think happened. Jessie, I want to know whether you think this could have happened this way. When Justice Alito's draft opinion was leaked, all of a sudden, a lot of pressure came on Justice Kavanaugh. Senator from Maine, what's her name? Collins said, oh, he betrayed me. He made me think he would uphold Roe v. Wade. And although Alito in the draft opinion said this doesn't touch Obergefell and the other things, I think Kavanaugh was a bit spooked by this objection. And so he writes a very strong concurrence saying, we're only deciding this on abortion. We're not going to touch the other things. We're making no moral judgments. And he's trying to push away. This is my theory of what happened. And that then triggers Justice Thomas, who then says, well, wait a minute. They are the same, so we can go after them if we want to, and I want to. And I think so. But I don't think either of those judges are going to get Roberts or even the others to go along with them. Yes, except for Griswold, which I think is lock solid, and it's grounded on a logical point. You cannot protect marriage by invading the privacy of marriage. It just doesn't make sense. Griswold is solid. That's not going to move. But Obergefell, it would be in a way suspect to being overturned by these rules. But I'm going to give you a non-originalist reason why it won't be. I told you, as I was saying, that the three made actions of substantive due process, which protected slavery, which protected the right of a businessman to impoverish the worker, which protected the right of a woman to terminate the life of her child, all were victimization ones. But the others are not. The others are relational ones. Take Pierce versus Society of Sisters, where the court held it was a substantive due process right of parents to be able to tell how their children would be raised. Take Griswold, which was a relational right of a husband and wife to determine how and in what manner they would have sexual relations. Take Obergefell, in which it held that sex differentiation was not a barrier for people having certain relations under the law. I think that kind of sense of difference to the impact. That's why Alito says they're different, because in an abortion, you've got the question of a life of somebody being taken. It's a different quality issue than you have in the other three. So I think the other three are going to stand, and there won't be any trouble with that.
Thank you, Professor Forte. Professor Hill, you have 2 minutes.
So you may be right about what happened after the leak. I don't know. I think certainly you're right that it will depend on Justice Kavanaugh. I think going forward, he seems to be the sort of middle swing vote on these, certainly on these issues, and whether he will go along with an opinion overruling the right to contraception or not, I think it is in his hands. I think that his judicial decisions have been fairly intellectually consistent in general. I think he has a perspective, and so we'll see which way that cuts. You can say we're not deciding X. That doesn't mean when X comes before you that you are necessarily going to rule the way you've suggested, right? I mean, it's sort of, there's no pre-commitment here. I just want to point one thing out, though, about what Professor Forte said here about Griswold, which is that Griswold is about marital privacy, and that's why it's rock solid. That is, in fact, what the Supreme Court decided in Griswold initially in 1965, that the right to use contraception within the context of the marital relationship was constitutionally protected. It wasn't until 1972 in Eisenstadt v. Baird that the Supreme Court then expanded that to single people and said, if the right to privacy means anything, it is the right of the individual, married or single, to make such a fundamental decision as whether to bear or beget a child. This is exactly the move Mississippi made as well. In the Dobbs case, the state of Mississippi said, grasping at straws, trying to figure out why Griswold wasn't also on the ropes, said that case was about marriage and use of contraception in marriage. So I guess there's some consensus on that side that contraception can stay legal in the context of the marital relationship, but as you can see, it's already put in question outside of that relationship.
Thank you, Professor Hill. I would like to invite Mr. Recke to ask his second question.
Professor Forte, in your article titled Life, Heartbeat, Birth, a Medical Basis for Reform, you assert that detectable fetal cardiac activity is more compelling than viability is in arguing the state's interests in protecting the unborn. And of course, it occurs earlier in gestation. Do you think that as time passes, this determining point will be redefined at an earlier stage of pregnancy?
No. From all the medical evidence I've read, no, because you don't perceive cardiac activity until there's implantation, right? And so before that, you can't really have a medical determination of what's happening to the fertilized ovum. It may not even implant. at that. So I think that's going to be the only real line you have. But you know, you raised the question about viability, and that's really interesting. Viability was the weak link of the Casey opinion. Casey never really looked at why it should be viability. I mean, a lot has been made fun of about this, about the undue burden test, but it had more substance to it than viability. Viability line is, first of all, when obstetricians talk about a viable pregnancy, they don't have a line. Viable pregnancy is the fetus is alive at any time. That's how obstetricians talk about viability. Viability was a made-up legal phrase by Justice Blackmun, where he said a child could have a meaningful life on its own, and therefore the mother could be compelled by state law to bear the child for the last 3 months. Well, on its face, it makes no sense. If a woman has a right to terminate a pregnancy, and the child could be born alive, then you could pass a law saying, all right, after viability, you can terminate the pregnancy, but with the method most determinable to preserve the life of the fetus. Would make sense, right? Supreme Court struck that down. So now you have a situation where if the fetus can't survive, the woman may abort it, but if it can't survive, the woman may not terminate her pregnancy. It's like a skipper of a lifeboat who's told, if you get somebody who can't swim in your lifeboat, you can throw him overboard. But if he can swim, you've got to bring him into port. It just made no intellectual coherence whatsoever. Secondly, viability is woefully difficult to determine. If anything is vague, it's viability. When you ask doctors when viability is, the percentages vary across. Well, the earliest is 20 weeks. They sort of group around the highest percentage around 23 weeks, 22, 24 weeks. And then, how do you measure whether a child is viable? Do they look at that specific child, check the heartbeat, check the circulation? No, they do a measurement. You know, crown circumference, a crown to rump thing. And then they say, oh, it's this big, and we think the woman's been pregnant, because that's a guess too. This number of years, according to my graph, yes, it's. You can't determine whether a particular child is viable at any time. And that was basically what Chief Justice Roberts was getting at in his concurrence. He said viability is a chimera. It has no real substance of determination. So he would have supported the 15 weeks and gotten rid of the viability line. So that's why the viability line is not a predictor of anything. I mean, heartbeat is hard and fast. I mean, it's within a couple of days you can determine whether there's cardiac activity. You can't with viability. And if the statistics are what I think, Professor Hill may have different statistics, and I'd be glad to know about them, that this is a good predictor that child's on the way to being born. That child's on the way to being liberated into life. It should be preserved. That liberation should be preserved. That's why I thought cardiac activity is the right line to hold.
Thank you, Professor Forte. Professor Hill, you have 3 minutes.
So in case you missed it, that's correct. In the lifeboat analogy, the woman is a vessel, then, I guess. Yeah, you walked into it again. I've called you out on this one before. Okay, so I find that interesting. So I think, look, is viability an arbitrary line? Is the heartbeat an arbitrary line? Does the law depends on arbitrary lines? If we're going to legislate these issues, any line is going to be arbitrary in some sense. The 6-week or the heartbeat, I should say the heartbeat, which is really, it's not a heart. No fetus has a heart until much later in pregnancy. It's electrical pulses in that later become what forms heart tissue in a very early embryo. Remember, 4 weeks post-conception. There's no medical significance to that. First of all, heartbeats do not correlate to any medical definition of life or when life begins, life or death. Death either. When your heart stops is not when you're dead. Death is correlated with brain activity, not heartbeat, is the medical understanding. Why 95% chance? I mean, what is the chance at 4 weeks? Maybe that's the right percent chance that it's going to carry to term. Why not, 7 weeks? Maybe it's, the same percent chance. I don't know why we're picking 95% chance or why, it's just, but I will say that, now really that 6-week line was chosen by the anti-abortion folks as a way to get around the viability line, to redefine what viability should mean by picking this other point that sounded reasonable. I don't think anyone really feels like they need that 6-week point anymore on the anti-abortion side. The goal is really to ban abortion throughout pregnancy from conception. I think the thing about the viability line is that it has, like any other line, is arbitrary, but has some moral intuition behind it. It lines up with folks' intuition about when it is too late to make this decision. A lot of people's discomfort with later abortion, which is not the same at 4 weeks post-conception. And I think this sense that there is even the quickening line that the common law drew, which was when the woman could feel the fetus moving, was, similarly this sense of when do we feel like this entity has interests that are potentially protectable, separate, at least by the state, separate from the woman's interests. I wouldn't say that whether or not I agree with that specific intuition, it is certainly one that grounds the viability line and is widely shared.
Thank you, Professor Hill. Professor Forte, you have 2 minutes.
Right. I don't know any pregnant woman that's ever said, I have an entity that needs to be protected, and I think I'm going to have an entity born in 9 months. No, it's a child. It's a child. That's what they know about it. If you want to know the biological definition of when life begins, she says, Professor Hill says that there's no consensus, life begins at heartbeat. She's right. She's right. The biological consensus begins with conception. That's when your individuality began. Then you were set. You didn't change one day after birth or one day before birth. Justice Blackmun said viability is the point where a fetus then can have a meaningful life on its own. What is a meaning? I'm still trying to get a meaningful life on my own. What did he mean by meaningful life on its own? Mean it could survive on its own? No born child can survive on its own. No teenager can survive on its own. We are all dependent in our lives and more or less get more independent as we grow. But a one-day-old child is not viable in the sense that it can carry on by itself. What's the difference? The difference is the specificity of dependency. A child that's born is dependent on indeterminate people. It can be the nurse, it can be the mother, it can be someone else, but it needs somebody. A child in the womb before 6 months is dependent only on one person. And that gives that person the right to end the life of that child? Sorry, I don't get it.
Thank you, Professor Forte. Since we are short on time, I'd like to now open to questions from the audience. Professor Forte, Professor Hill, you both have 2 minutes to respond to the other guest speaker's point. Yes, Professor White. Microphone will be coming up to you.
I'm sorry I couldn't attend earlier because I have class, and maybe you covered this a bit, but it seems to me one of the fundamental questions going forward is, for example, if an inhabitant of, a resident of Arkansas gets an abortion in Illinois, are they subject to a murder prosecution under the law of Arkansas? And so what does it mean to have states with different laws? Because Forte's position has been that this essentially is something that should be left to the states. But how that is recognized in different states, we have things like the Fugitive Slave Act, we've had a lot of disputes about that. So what are your positions on the extent to which it actually works to have states with different laws?
Professor Hill?
Oh, do you want me to go?
No, I want to go first. But I'm going to tell you, you should say ditto after I speak. Ready? Ready?
We'll see.
All right.
Hasn't happened yet.
Yeah, and we'll try. We'll try. I think under the Privileges and Immunities Clause, no state can criminalize an activity outside of its borders that's legal in another state, period. I think, and I know some people on the right disagree with me, but I just don't see it. I've taught constitutional law 40 years. Privileges and Immunities Clause is one of my favorite clauses. It's the right to travel. I don't think any state can penalize a person who travels for just traveling out of state to get an abortion. That's my position.
Nope, it's not going to happen. I'll say the law is considerably less clear here than we might like it to be in terms of whether or not that's within the scope of the right to travel. Without going too much into the details, I will just say, though, that I find it inconsistent with the point of view that this is a person, a child from conception, to then say, but you can take your child to another state and murder it, if that is the view, right? That the state doesn't have a sufficient interest, so that it isn't a compelling enough interest to overcome the Privileges and Immunities Clause to take apparently a living human being with equal status to the person whose body it depends on into another state to kill it. So I think that that's a logically inconsistent position. It's not, again, I don't take the position that the fetus is a person, but I think if you do, then it's deeply troubling.
Okay, you can visit me.
Thank you, Professor Hill. Any other questions?
If I can just quickly follow up. Please, just logically, does it make sense to have different states define life in different ways?
Professor Forte, if you would, let's try to put a minute on the clock, yes? Thank you.
Yeah, on an issue like this, it does. It does, because this issue is not, some people on the right, John Finnis and Robbie George, have said that the 14th Amendment protects persons from the time of conception. I don't think it does. I don't think it was intended to do to that. I mean, the fetus to me is a person, but the Constitution does not protect it until it is born and put equal protection rights upon it. What we do to protect that person is to pass legislation to protect it.
Professor Hill?
I mean, I think there we get really to the crux of the matter, which is that even extremely pro-life individuals don't really believe that this is a person. They believe that this is something that has moral value, that they want to tell you how much moral value it has, and what interests of yours or what rights of yours are or are not trumped by that moral value, but that it's not equivalent to a person walking around. And what Rose said was that no state can define life as beginning, so early that it completely trumps the woman's ability to make this decision, right? And that was the national settlement that we had until a couple of months ago when the Supreme Court decided Dobbs and said, no, our moral intuitions about the value of this entity are what decide the rules.
Thank you, Professor Hill. Thank you, Professor White, for the questions. Any other questions from students specifically? Yes.
So I just want to know that, what is your opinion on if it is a human being and it's seen as a human being, then why can't we make laws where it is seen as a human being? So why can't we take out an insurance policy to protect that human being that is growing inside of us? And why is it not seen as a second person if a pregnant woman is driving a car? There was a case recently in Texas about that. I just want to know what your opinions on that is.
Oh, I definitely agree. In fact, we have laws doing that. See, the pro-life tactic was to protect as many children as possible without penalizing the woman, because they realized this is not a question of getting at. Most abortions are done by abortionists, and there are a few in the country. They do dozens a day. It's not as if The doctor in the Cleveland Clinic does a lot of them. They do them when they require them in terms of necessity. But yes, so we have laws that protect the fetus. We have laws in which you can take out policies to protect the fetus to be born. We have laws that protect the fetus when born for inheritance rights. We have all kinds of laws that recognize it as a person. It is not a person in terms of the 14th Amendment. That doesn't mean that we can't recognize it as a person for other purposes, because it is a person. A corporation is recognized as a person for purposes of part of the 14th Amendment. It's recognized as a person, but it's not a human person, right? It's a created juridical person. So the real person, the human person, is in the womb, and it can be protected by legislation. That's all pro-life people are asking for.
Thank you, Professor Forte. Professor Hill?
I guess maybe I'll just take a different spin on the question and just say that, I think that is one of the reasons why we may not see this sort of legislation too quickly, although it is a radical position that some anti-abortion folks, not including my colleague here, but do take that the fetus is a person that's protected by the 14th Amendment and is entitled to all the rights, constitutional rights, other rights. I think that the implications would be, shockingly broad, and that they would have, and I do think that legislatures are loath to wade into that too quickly. I think for inheritance, for apportionment, voting purposes, do you get to vote when you're 17 and 3 months, right? When do you get to drive? Do we have to count all the figure out who's pregnant and count those embryos in deciding where to draw our district lines, right? And also then, again, the implications for certain forms of potentially contraception or in vitro fertilization as well. What are you going to do with all those embryos that are stored, that people create when they engage in assisted reproduction? So, I do think that it may be a while before we see anyone going wholeheartedly into that personhood, sort of what's called the personhood approach.
Thank you, Professor Hill. Now, Now, with the time that we have, our guest speakers will now proceed with closing statements. Professor Hill and Professor Forte, you each have 5 minutes. Professor Hill, you may begin with your closing remarks.
Okay, thank you. Well, and I may not take 5 minutes. I feel like we've covered really a lot of ground here in our discussion today. The one thing I want to say, or maybe 1 or 2 points I want to make, I think are that, again, as I kind of alluded to at the end here, I don't think very many people really think it's a person, or that it's a person with equal moral status to the person, that the fetus or the embryo or the fertilized egg really has equal moral and constitutional status to the person that's carrying that fertilized egg, embryo, fetus. I think, I think what people are really saying is that is something that has moral weight. You can call it a potential life. You can call it, a fetal life. You can call it whatever you want. You can call it an unborn child. But what you are really saying is that it has some moral value that is not nothing, that does deserve protection. And, I get that. And I'm not sure I disagree with that. I just think that it's up to individuals to decide for themselves what the moral value of that is and what is important enough about the individual's situation to outweigh that. Look, if I can't have another child, if I, my health will be put at risk, if I already have too many children, I cannot possibly find the time, attention, money, whatever it might be, to have another one. I think that those are decisions that we do and should entrust to people to make with whoever they consult, their spouse, their partner, their family, their spiritual advisor, and that it's really not up to the government to say how much moral weight to put on the fetus, the embryo, the fertilized egg, and when its interests outweigh the woman's interests. This is, and again, Professor Forte kind of alluded to this, that the uniqueness of this situation is that before viability, the fetus is solely dependent on the woman to survive. and the woman's body. And in no other corner of the law does the law make people sacrifice their bodies for someone else. And again, I don't know how many people in this room have been pregnant before, but I can tell you it's not a small thing. It's not a small sacrifice of your body. And I had super easy pregnancies, and a lot of people didn't. You know, we don't make a parent give their kidney, you know, if their child would die without it, right? Every parent I know would do it, right? But the law does not require that. We leave those moral decisions up to individuals, and certainly to demand this kind of sacrifice of women and only women. That's what the law does. It demands this sacrifice of women and only women for something that Justice Alito has decided has sufficient weight that you can be forced to go through 9 months of pregnancy to serve the moral status of this entity. I think it's really telling to say that there's sort of just the extent to which the woman and her body and her life choices are really just absent from that discussion. And to the extent that, as Professor Forte pointed out, these abortion laws don't allow prosecution of the woman. Again, if it's a person, I think she's complicit in murder. I don't see how she wouldn't be under that theory. What is the theory for exempting the woman from prosecution? That she's somehow bamboozled by the doctor. She doesn't know what she's doing. She lacks moral agency. What is the explanation if this is really the sort of moral offense that we think it is? I don't know why she should be exempt from, the costs of that decision. So, I think that women are moral agents, and that they can weigh the value of the fetus or the embryo or the fertilized egg against the other very important responsibilities, duties, decisions they have to make in their life, and that the state should just stay out of it. And that's what a constitutional right to terminate a pregnancy would mean.
Thank you, Professor Hill. Professor Forte?
When did you come to be? When were you? Was it one day after you were born? Or was it the same? Was there a different you one day before you were born? At what point, when we go back, did you cease not to have been you? You can't do that. Is it geography? Does a person have a right to life in the United States but not in North Korea simply because of geography? Is it 5 centimeters in the womb as opposed to 5 centimeters outside the womb? Is that what we determine what life is going to be? What are we going to say? I'm going to tell you a story. And I'm old. Back in the 60s, I was a graduate student in England, and I traveled down to Europe during the vacations. And in the winter over Christmas, I traveled down through France and up into Germany. It was West Germany then, and up into West Berlin. And I happened to meet on my travels 2 very lovely university women. And as we were talking once, we were on the train, and they said, "Why don't you come tomorrow night to our apartment and have a glass of warm wine?" That's how they celebrate Christmas everywhere through Europe, a glass of warm wine. So I did, and I went. Very, very fun, a lot of fun. We were talking. And their names were Sieglinde and Irmgard and Sieglinde. And being a very undiplomatic young American, I said, "Where did you get names like that?" And they said, "Well, we were born during World War II, and it was very important to have Teutonic names for your children." And that all of a sudden triggered in my memory that I had read the summer before an article in Time magazine that the West German government had been requiring education as to the Holocaust in the schools, in the high schools. And so I said, "Is that true? Did they show you the films? Did you have to see those things?" And they said, "Yeah, it was true." I said, "What did you think?" And they said, one of them said something that chilled me to the bone and has affected me ever since. She said, "We felt like going home and spitting in our parents' faces." And when I left that night and walked through the cold West German air to my pension, I said to myself, no matter what I do, whatever mistakes I make, I hope my children never think that of me. And as a parent, I've made many mistakes. But then a few years later, Roe v. Wade came, and I knew. And so the question I ask myself, and I ask you, when your children and grandchildren ask you, and they will, what were you doing when 40, 50 million children were turned into so much medical waste? What were you doing at that time? What will you tell them?
Thank you, Professor Forte. I would now like to invite Ms. Wu to deliver her closing remarks.
Thank you, Mr. Pascal. Ladies and gentlemen, the Society for Constitutional Policy members express our most sincere appreciation to Professor Forte and Professor Hill for joining us today. We give special thanks to the President, the Office of the President, and the Provost for their support. Putting together such an event took a lot of people and resources. So we'd also like to thank our many contributors: the School of Law, the Department of Political Science, the Center of Policy Studies, our student panelists, moderator, timer, and volunteers, and our wonderful advisors, Dr. Dahl, Professor Lucker, Professor Tartikoff, and Dr. White. Lastly, I would like to invite everyone to join us at our post-program reception on the second floor, provided by Ben's Place. Thanks again for coming. We wish you a great rest of your night.